I'm very happy to present you our work. Let's see the presentation. Today, I want to tell you about comprehensive analysis of innovation in the criminal legislation of Ukraine on the protection of animals from cruel treatment. My name is Simchuk Natalia, and let's start our presentation. The problem of implementation, the security function of criminal law is essentially based on the scientific solution, criminalization and decriminalization, using scientific tools as criminal law and criminology. As part of the study, the question of scientific interest is the study of the criteria of criminalization and decriminalization, which are distinguished by both domestic and foreign scientists and taking into account the best experience in the formation of criminal law policy. Solving the question of the theoretical foundation of the security function, criminal law will develop the kind of coordinate system in which both criminal law policy and particular activities of law enforcement agencies. After all, not in Ukraine yet, an effective mechanism has been developed that allows to ambiguously determine whether this or that illegal act reaches the limits of criminal liability or application of the possibilities of criminal law to counteract this or other encouragement is optional to minimize the harmful effects of a particular category of offenses. Development of particular science recommendation will have both important theoretical significance and help in this area, particular increase of the level of legal technique of the criminal code. Despite the fact that the problem of animal cruelty is not new, it unfortunately does not lose relevance. As in the legislation, animals first of all have the state of a sin. It is necessary to emphasize especially that is object of criminal legal protection in this case. The legislator classifies this crime as a crimes against morality. The group of norms of criminal law of Ukraine also include, for example, norm on protection of freedom or religion. Great importance here is the understanding of the logic of the legislator. As Lehova points out, in crimes against religion, the failings of the person and the psychological component connection with it have great value. In this case, in the study of the punishment of cruelty to animals, also in the first place are not protected animals, human feelings. Along with this, cruelty to animals is a good example for the study of the protective function of criminal law. Given the recent changes in the legislation of Ukraine, which have affected both the responsibility for ill treatment and losses as a criminal offense and the basic legislation, the study of this issue in Ukrainian context has become very relevant. The proposal of this work can be considered as a comprehensive legal analysis of innovation in the criminal legislation of Ukraine on combating cruelty to animals, the protection of their adoption, and respect for use. Researchers for different countries pay a lot of attention for various aspects of protecting animals from cruelty. Magoba points out when it comes to dogs and cats, people perceive of the animals' cruelty are similar. However, if we talk about the other group of animals, activists and farmers, see this issue in very different ways. Believer in research of animal cruelty in Bulgaria conducted a survey that shows that there was a significant difference in the protection of animal feelings and protection of animal cruelty in different demographic groups. At the same time, cruelty and animal abuse are important risk factors. Such factors often precede the commission of serious and dangerous criminal offenses, for example, as assault, domestic violence, and homicide. McLean indicates a connection between violent family experience in childhood and subsequent violent action. Granville, who has studied animal cruelty and Australia, points to the general nature of the problem. Animal mistreatment is common, uninterrupted, and mostly neglected. and fulfillment of the international obligations, the law of Ukraine on amendments to the 13th legislative act of Ukraine concerning the implementation of provision of certain international agreement and directive of the European Union in the field of protection of fauna and flora was adopted. According to the new version of the article, cruel treatment of animals belongs to the vertebrates, including harmless animals, violation of the rule of transportation of animals if such actions have led to bodily injury, mutilation, or death of the animal, inciting animals against each other, committing with hooligan or selfish motives, as well as propaganda, public calls for actions that show signs of cruelty to animals, dismissal of materials calling for such action shall be punished. Cruel treatment of animals is compatible with the requirements of morality and humanity cause moral harm to humans. Your action of article of the Criminal Code that provides a punishment for animal cruelty has a number of changes. The main difference from the previous inversion is the addition new way to committing a crime. Violation of the rules of transportation of animals in such action have resulted in bodily injury, mutilation, or death of animals. Additional of propaganda of animal cruelty as a new way of committing a crime, exclusion of an indication of the intentional nature of animal cruelty, a qualified type of crime which previously is the commission of a crime in the presence of minor or juvenile. As a particular qualified type of crime, a new method has been added: violence against animals and satisfying sexual desire. Part 4 has also been added, which specially punishes the cruel treatment of animals for the purpose of creating images, work, film, video, audio products, or the sale of distribution of image, works, film, video, audio products that promote animal cruelty. As for the understanding of the objective side of the animal or criminal offense, in this case, it can be committed both by action and inaction. The result of criminal offense must be infliction of bodily harm, injury, or death to the animals. At the same time, the death of animal in itself, for example, slaughtering a pig for meat, is not a cruel treatment. That is, the crime is material, not formal, so in the case it is not obvious. The most common way to commit a crime can be considered in the case the actual action which is contrary to this criminal offense, not detailed cruel treatment of animals belong to the vertebrates, including stray animals. It is, in this time, it's necessary to understand that each species of animal has its own special housing condition, which the owners must know and follow. And what is the norm of one species of animals will be cruel to another. According to Article 22 of Criminal Code of Ukraine, the subject of this crime can be physical person from 14 years old. Scientists generally believe that the animal cruelty can only be committed with a deliberate form of guilt. However, in reality, this issue is debatable because the actual cruel treatment of animals by improper keeping them is also possible with carelessness due to the ignorance of the condition of keeping animals and their own carelessness. The motivation of this crime is mostly not qualifying importance. However, amongst the motives of distinguish both certain deviation of personality and low moral qualifier and poorly material motives. Here we can see the list of reference for these articles, and that's all. Thank you for attention and goodbye.